Ooh, we're live. I always mean to start on time, but it's one of those situations where I had to put up a pet. Hey everyone, Bart McLeroy here for the Professor Bart's office hours. This is one of those things where I am just going to assume that I have all the right things selected, so I'm just going to assume that the sound is working. Did I have this doubt last week? I think I may have. That's fun, isn't it? Um, yeah, all of that seems right. External mic, yeah. Got that clipped on. Okay. Let's hope everything is working. I attended a workshop last week in relation to doing live video. And, well, specifically, this is for recording for classes. And one thing they said was, you should never use a background. Just have natural background because that way the editors can go in and change things if they want to. But I'm in my messy home office, so I'd rather have a clean kind of. I like this background. It's pretty cool. Looks like something out of Blade Runner 2049. Am I the only one who saw that movie? It's no, but still not exactly a home run. All right. Um, yes, I have not quite a slideshow, but I just want to have something that I pull up that have available to reference. That is because, yeah, one of the points of this web series, part of it is obviously to um, talk about real estate topics, but the general idea is that we are using this as a kind of springboard. So one reason why these first few weeks I want to talk about dispute resolution topics, because I have a course I wrote on dispute resolution. It's intended to be an 8-hour course. I think I'm going to trim it down into 4 2-hour courses. That's a little more digestible for most folks. It's the only time I ran it through. It didn't take me that long, so I want to make sure that I am doing have all the material that I need. So, at a minimum, if I can sit here and talk about it with you, I can figure out if I need to add more material to it, or if it's really just like in the delivery of it that it would tend to become more robust as a course. Right? If you've never given a course before, that's time can stretch one of two ways. Either you can run through all your material very quickly. I was talking to an instructor once who said, "Oh, it was a 2-hour class, and I was pretty much done with all my material in 20 minutes because I spoke so fast and I was really nervous." Which, so then I had to vamp for the rest of the time because in real estate CE we have to fill out the time, don't we? So that's always a bit of a fear. Um, the other way it can go is you have so much material that you will never get through it all, and that's something I have to resolve. Just not touch my face today. I noticed that in the little clips that Substack made. I have to not mess with my facial hair or glasses or whatever. All right, that's my own personal to do for today. Um, the late great Dr. John Bain from University of North Texas, he basically had this hundreds and hundreds of slides PowerPoint just based on general real estate topics. And like, if he saw a news story that was interesting, he'd throw the headline in or other things. And basically, he would just boot up this spreadsheet and start at some point and just go for as long as he had and just talk about different topics. It was kind of an amazing idea, honestly. No two versions of that were the same. And he would always tailor what he actually ended up talking about to what was going on in the group, etc. But that was that's a different strategy, one I haven't tried to replicate. Although um, the man had longevity in the real estate education field and was very renowned. So there's worse people I can emulate, that's for sure. Yeah, I was thinking back to last week and to the discussion of negotiation, and to especially the discussion about crafting win-win solutions, which is something people frequently say they want to do, right? That way we enlarge the pie. That's, in a way, it's kind of how we show value in our transactions or in our interactions, is by coming up with new ideas that other people haven't. Um, I had a situation yesterday where it was only later that I realized I hadn't crafted a win-win solution, but after thinking about it a while longer, I realized why that was. So maybe this is an interesting addendum to that. So I had plans yesterday to play pickleball with a friend at 11 a.m. So a Sunday morning game, kind of get our legs stretched and the blood flowing, and then she texted me couple hours before and said, "Hey, I'm really not feeling well. I got a bunch of sinus issues and stuff. I'm going to have to cancel for the day." Okay, no problem. I'm not going to insist anyone run around and try to hit a pickleball if they are not feeling well. I wouldn't want to if I wasn't feeling well. But what I ended up doing was, even though I wouldn't get a refund back, I ended up just canceling the appointment because it was too close in to get any sort of refund or credit back. It wasn't until later that I remembered that this particular pickleball court has little ball shooting robots that you can rent for $10 an hour. And then when I remembered that, I had this thought of, oh, I could have gone, paid $10 more, gotten use out of my hour, and also just spent the whole hour like returning serves or practice dinking, or whatever. I don't know everything the little ball shooting robot can do, right? But like, that idea would have been win-win, right? Because as it was the options seemed to either be cancel and get nothing back, or go and there's no one to play with. Like, probably could have recruited someone at the field, right? But the field, the arena? No, that's not right. The court. Probably could have recruited someone there, but that's I don't know. I'm not very good yet. Hey, would anyone really like to utterly humiliate me on the pickleball court? I'm sure there's people that would. That'd be fine. But no, um, what was missing there from my ability to construct that win-win scenario of, oh, pay $10 more and I just work on my returns. Uh, what was missing there was the element of time, and kind of so time to think about it, and then also the stress of having a looming deadline. Like, something unexpected happened. Oh, I need to make a decision now. I didn't, but that's what my brain was telling me, right? You need to make a decision now. So that is, I think, another element of that to be considered. If you really want people the ability to craft win-win solutions, there needs to be time, and kind of unstructured time. No looming deadlines. I mean, we all have looming deadlines for everything, right? But like, not like, oh, this needs to get decided in the next 15 minutes, sort of thing. Unstructured, and mostly in business, it doesn't have to happen in the next 15 minutes, right? That's the thing about it. That's something I always complained a bit about. If back in my corporate days, if someone would, you know, call, or after work hours, or email or something, that we have an emergency, and I would always think, oh, a real estate emergency. Like, every now and then there is an emergency, right? Like, oh, a leased space burned down and we need to do something, make sure we have alternate officing arrangements for the people that work there. Okay, there's only so much we can do before working hours tomorrow and start finding a new place, right? But uh, in part, that would be an emergency. But in general, it's an emergency because someone's worked up about it. It's not an actual emergency. So yeah, that's something that, in retrospect, I do think needs to be part of the equation for creating an environment where win-win solutions can come to pass, is unstructured time, time to think, and an environment where kind of free thinking, free flowing ideas are allowed and welcome. Um, And I would say in at least the corporate world, there does not tend to be a real push towards making sure people have unstructured time that isn't like booked out. The idea is that if you're at work, you should be doing something, right? Like earn money, create shareholder value, um, because probably whatever job that person is doing used to be done by two people, and maybe they used to have admin support, but now they say, "Oh, AI is your admin support," something along those lines. So, yeah, this we get better results, and we have the ability to craft win-win solutions. I think when we are able to take a little time and think about things. But I think that is an idea that is in increasingly short supply, I think, which is an absolute shame. I'm just looking at the interface here. I'm not going to stop fretting about this, unfortunately. The interface, on Zoom, when you're talking, there's that little meter goes blip, 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 blip. You can see that like there's sound waves, essentially. Um, Here, there doesn't seem to be that. That's possibly a downside to the Substack Live interface, is that you can't really see if something's happening. So I'm just going on faith here. If I talk for an hour, or more likely for 50 minutes, if I talk for that length of time and then there's no audio, I'm not going to do it again. Uh, that's the beauty of live, baby. I've done that before. After quizzes in the classes that I teach, the pre-licensing courses, I will I'll record recap videos, and I will go through the results, give some handy tips, that sort of thing. And one week the students were like, "We can't hear anything." Oh, darn it! For some reason, just the audio not work, did not connect, what have you. So had to redo it. And fortunately, those videos are only like 10 to 15 minutes each, so it's a bit of a pain, but it's doable. Yeah, this for an hour where it's a bit of a free flowing stream of consciousness ramble sort of thing. Not gonna, not gonna redo it. So let's just hope that everything is going the way it is supposed to. Fingers crossed, folks. All right. So I wanted to continue on the dispute resolution discussion because, again, my idea initially is I want to flush out some things I've already written for a class, make sure that when I actually do turn these into 4 2-hour classes covering a wide variety of topics, that I do have enough to talk about for those times. And it is less intimidating as an instructor to say, "Oh, you have to fill 2 hours," as opposed to you have to fill 8 hours. So I do honestly think that between audience participation and between just kind of crap that I know, and the fact that if you break it out into 4 2-hour chunks, you can do a little bit of overlap, because it's not always the case that people will be tuning into every single one. So again, it's a bit of a less daunting prospect. All right, so I'll talk a bit about alternate dispute resolution methods. So first of all, don't forget negotiation. I think I mentioned this last week. Negotiation is the original form of dispute resolution, right? Just people talking things out, people negotiating a settlement to whatever dispute they may have. And in fact, when I talk about this idea of alternate dispute resolution or alternative dispute resolution, um, we're saying an alternative to what, right? Well, the answer is an alternative to lawsuits. That's the answer. We might ask if we need an alternative to lawsuits. Aren't lawsuits good? The fact that we can take someone to court and sue them if they've done us wrong, for example. Yes, having access to a justice system to peaceably settle our grievances is a good thing. But also, you have to look at the timing as well. So the average real estate dispute requires 284 attorney hours, $66,000 in fees, 34% of hours are spent on trial-related activities, and only 8% of hours are spent in settlement discussions. That's very interesting. Now, I'll say this, you might think, well, what if we just had a system where that was flipped and then you had to spend more time in settlement discussions than on trial-related activities? Um, there, there is there is wisdom in the idea that you have to go through certain steps. It's kind of like the um, stages of grief, in a way. You can't just jump straight from uh, bargaining to acceptance, right? You kind of have to go through the stages. It's the same thing with a legal dispute. It is rare that the parties are able at the outset to be in the mindset of I'm ready to settle. Usually it takes a bunch of work to get them into that mindset because when parties are saying like I'm going to sue each other, um, it's because they think they're right. Typically, it's the rare person that would actually be honest with themselves and say, "I know I'm right, and still I'm, or I know I'm wrong." Let's back that up. Take two. It's rare that a party in a lawsuit will say, "I know I'm wrong, but I'm going to sue you anyway because I think I can just outmaneuver you." That's going to make a good Substack live clip right there, baby. Let's see if it let's see if it automatically selects that for me. That would be funny. I really liked the way that last week the Substack carved up the larger video into some small bite-sized clips that all seem to have a pretty coherent theme to them. So we'll see if it does that. That'd be a very small clip though, so I think I'd be surprised if it did that. Yeah. So, and I especially have seen this when I've worked as an arbitrator for FINRA, the Financial Industry Regulatory Authority. The parties at the outset are not ready to settle. That's not the mindset they have going into it. They usually have to go through the discovery process. Well, that's part of going through FINRA is they go through the discovery process. So they're suddenly exposed to a bunch of information and they start working on their evidence packet. They start working on the rebuttal packet to address what the opposing side has to say. And I find it tends to go one of two ways. One is the parties settle before we even have the first hearing date. They've seen the evidence one way or another, and they've made some sort of internal calculation in order to say, "Hey, we don't we think it'd be better to settle than to face an uncertain interest going forward, uncertain outcome going forward." So then they settle. The other version of that I've seen is we get 1 or 2 days into a hearing, and normally for these FINRA hearings, we block out a 5-day week for the hearings. They'll get 1 or 2 days in, and then we'll get a notice. The arbitrators will get a notice saying, "Hey, the parties have settled." So that tends to be how it goes. I've been on the FINRA arbitrator roster for 10 years. I've been involved in a variety of cases, and I've had exactly one case go through the whole hearing process to the point where we, as the arbitration panel, render an award. So that is the rarity at that point. Um, yeah. So normally it is a situation where the parties, partway through, start doing a calculation as far as their likelihood of winning, what they're going to get out of it. In fact, there's an important consideration in a lawsuit. Well, let me back up and I'll say that is why it does kind of make sense that so much time is spent on pre-trial related activities and that settlement discussions would take relatively little time and or when the parties, for example, if a judge says you're going to go to mediation, they spend hours and hours on attorney's fees before that, and they'll spend a day in mediation and frequently get the case wrapped up. But if the judge at the outset, before any discovery or anything else, said you need to go to mediation, odds are they wouldn't get anything settled. There is kind of like to everything, there is a season, right? Um, a case has to reach a certain level of the word I've heard most often is ripeness. And I don't necessarily love that term, but it is really an accurate way of describing it. It has to be ready to be settled. The matter has to be ripe for settlement. Again, I don't love that phrasing, but that's the one I've heard the most often. Okay, so here's some important considerations in a lawsuit. In a 2008 study, 61% of plaintiffs reported that they were financially worse off after a trial. Uh, Part of that was just the time it took for the lawsuit to resolve itself. It's not like you file a lawsuit and then next month you start the trial portion. Lawsuits will drag on and on for years, months if not years. Um, and at the state court level, where you have a lot of state courts and a lot of judges, and you're able to get on a docket relatively quickly, it could be like 18 years to 2 months, not 18 years, 18 months to 2 years maybe. And at a federal level, you're talking years and years, because there's just only so many federal courts and only so many federal judges, right? So the time it takes will really weigh on people. And also, let's say you win, quote unquote win. You get a judgment against the other party. Can that be collected on? At a property tax, I've had property tax consulting clients in the past who basically have told me, I sent them their bill and they're like, yeah, I'm not paying this. And then I have to do some mental math, If it's under $1,000, is it worth it to me to not even send it to collections, like just try and file a small claim against them? Like, how much time is that going to take? And if I get a judgment, then how do I go about enforcing that? Like, maybe it would be a fun thing to do. Fun? Like, I don't have enough on my plate, right? Yeah, usually I just say, well, I'm not going to represent you anymore. That's your punishment. Oh, the thought. Bart doesn't represent me anymore. I am punished. But yeah, all of those things all those factors mean that people have, after, people going into a lawsuit, they will think, oh, I'm right. This is a slam dunk. Any judge, any jury is going to see it my way, right? But then months or years later, so much money spent on attorney's fees, so much time. And people also say just like the mental toll it takes on you to go through that process. At the end, so many people say it's just not worth it. They're financially worse off. Their mental health is bad. It's just all around. It's better if they can get it resolved in a different way. Obviously, this will be different if we're talking about a civil versus a criminal case. Criminal case, we usually don't have the option to mediate a resolution or send it to arbitration or anything like that. So typically, we're talking about civil cases here. But in a civil case, we have a variety of stages, right? You start with case initiation. You move into discovery. Discovery typically takes a long time. Settlement discussions, that could be informal or formal, court mandated. Pre-trial motions, the trial, and then the post-disposition. So this could take quite a bit of time in a lawsuit. You're paying an attorney the whole way. Some people, especially when ADR, alternative dispute resolution methods, when they were being more adopted on a more widespread basis in the justice system in the 70s and 80s, people did ask, and I think it's a valid question to ask: is having an alternative a good thing, or does it deny you access to the justice system? I think what we've figured out over time is it is a good thing, and it doesn't deny you access to the justice system. I mean, maybe you've heard before this this statistic that 95% of lawsuits are settled before the trial. Right? So even before there were these formal alternative dispute resolution processes that were embodied in statutes, courts still had rules requiring settlement discussions. And sometimes in the middle of discovery, as I said, parties will just change their minds. Parties could run into budgetary restraints, especially if this is a situation where they are paying attorneys out of pocket as opposed to this being a thing that attorneys are working on a contingency basis. And yeah, as I mentioned, parties can just change their mind. I would also say I talked about the timeline over which a trial can happen, and we saw that statistic that 95% of lawsuits settle before a trial. What would happen if only 90% of lawsuits settle before a trial, right? We went from 5% of lawsuits proceeding to a trial to 10% of lawsuits proceeding to a trial. So that's doubling. I think the justice system, both at the local, county, state, and federal level, would just be thrown into even more of a shambles than it is. Suddenly we have twice as many cases to dispose of. Um, that would be it's a small percentage change, but a huge difference in how these cases are handled. Um, and there are apparently some countries where it is considered very much a cultural norm that like you don't settle because that would indicate that you think you're wrong. So you have to go to trial on everything. And in those countries, um, you could see wait times for trials to begin of 7+ years. So that is if the argument is access to justice, justice delayed is justice denied, right? So if you're insisting everyone go to trial, or if there's this cultural insistence that everyone go to trial, but at the same time it takes so long to go to trial that the matter is either rendered moot, or that things have just kind of stayed still in people's lives in these areas during that period of time. It's not very helpful, I would say, if people are getting stuck on that. So we have these alternative dispute resolution methods, and these are embodied in state and federal statutes. These are embodied in court rules, right? So if you look up almost any court and look up their rules, they will talk about settlement discussions, mediation, referrals, that sort of thing. And incidentally, sometimes it's just interesting to go through and read those rules or read those laws, because every now and then I've picked up, oh, I'm qualified for that mediator roster, or I'm qualified to be an arbitrator for this program, right? So that's for me, as someone who's trained in all this, that's a opportunity for a potential source of income. So, uh, first, when we talk about alternative dispute resolution methods, as I say, do not forget negotiation. That is the kind of OG method of settling disputes. But then at a state level here in Texas, I want to look at the Texas Civil Practice and Remedies Code, Chapter 154. It defines 3 forms of alternative dispute resolution that I want to talk about here. Those are mediation. Those are what's called a moderated settlement conference, which is a form of early neutral evaluation. And then we have arbitration. So mediation is when an impartial third party, the mediator, helps to try to negotiate helps the parties negotiate a settlement between themselves, right? So it's facilitated negotiation, essentially. Early neutral evaluation can be a number of different things. It's typically when someone with subject matter expertise looks at a case and kind of gives their opinion. This could be one person or a panel of evaluators. They give their opinion on how this would be likely to go if they were ruling on it. And then we have arbitration, which is where, again, an impartial third party hears the matter at dispute and renders a decision. Arbitration can be binding or non-binding. We'll talk more about that later. In any of these procedures, mediation, early neutral evaluation, or arbitration, parties could be represented by an attorney, for example, or they could be unrepresented. Honestly, at a mediation, usually, and I've heard attorneys talk about this and say that, yeah, I love going to mediation because I sit there all day, I get paid my hourly rate, and I don't have to do much. Occasionally I'll have a client ask me a question about a point of law, and I'll give them an answer, and then we'll move on. Arbitration, it is more common for parties to be represented. That could be by an attorney, or depending on the form, it could be something else. For example, in the property tax arbitration system in Texas, property owners can be represented by an attorney, or a real estate broker, a real estate appraiser, a property tax consultant, or an accountant. So lots of options there. I think it really just depends on the kind of property. Excuse me. I think it depends on the kind of property you're dealing with, and just the kind of case it is. As far as the qualification of a neutral, so this is specifically in the Texas Civil Practice and Remedies Code, but I've seen it mentioned in other places. So I think it's become kind of a de facto standard that if you're going to be a neutral in these procedures, you should have taken at least a 40-hour course in ADR techniques, which I've taken a few of those. So, And specifically, if you are going to mediate um, divorces, that's a whole separate area of mediation. If you're going to be a divorce mediator, you need to have taken a 24-hour course in the parent-child relationship. And also, I think there's been an addition since then. It's like an extra 3 or 4 hour course in, I believe it's like domestic violence training. I have that note somewhere, but not in what I'm looking at. Or you could have other training or experience acceptable to parties. So, I've not done divorce mediation, so I don't have that special training, but I have taken several courses in ADR as well, longer as well as shorter courses. Um, I got appointed as an arbitrator recently. It was a landlord-tenant dispute. No, it wasn't. I'm sorry. I keep saying that when I talk about it. It was a property owner property manager dispute, so landlord manager dispute instead. But in their property management agreement, the parties had agreed that if they had a dispute, they would submit it to a neutral arbitrator, and that arbitrator would have training in dispute resolution and also be a licensed broker in the state where the property is located. That's just standard for that company's property management agreement. So yeah, they found me because I'm a broker and I also have training and experience in arbitration. So that was one of those weird situations. They didn't seem to have been referred to me by anyone. I think they just literally did a Google search, and my ADR webpage came up. So that was nice. Nice to have kept that up and eventually referred some business to me. There's also a discussion in ADR spaces about whether you need subject matter expertise or not. I've heard arguments both ways. So I've heard an argument that, well, in a mediation, like, well, if this is a construction dispute and they're submitting it to mediation, the mediator should know something about construction so that they can be knowledgeable about it, and then that removes a lot of the time required to get the mediator up to speed. So that's one argument towards the idea of a mediator should be a subject matter expert. On the other hand, I've heard many mediators say, look, I've gone into mediations not knowing much about the subject matter of the dispute, but what I do know is how to get parties to talk to each other. So they would normally say in the cases I've seen that it's rarely the subject matter that is, it's not like they're in mediation because they need a technical interpretation of a contract clause, for example. But just being able to talk to people, help encourage them to talk to each other and to create win-win solutions. Yeah, this wasn't a mediation, but this is the story a mediator told me. He said he was facilitating this group discussion, and it was this utility group, and they had a problem periodically during the winter with utility lines icing over, and they also had helicopters that would go out to survey, damaged utility lines. And someone mentioned, if a helicopter flies close enough to utility line, it knocks the ice off because of the backwash from the rotors. And they immediately came up with this idea of, as the helicopter is performing its inspections during the winter, if it can fly like above and a certain distance above the utility lines, then that can help reduce the requirements for maintenance because it'll keep the ice knocked off. I don't think you need to be a utility line expert to come up with that. I think what the individual telling me this story had said was what he needed to be able to do was to listen closely to the parties and help to get them talking to each other. So that's helpful. Yes. So then in early neutral evaluation, now that is a scenario where it does help to have some subject matter expertise, I do believe, because the idea is I'm giving my kind of expert opinion as to how I'd rule on this. And similar to arbitration, typically there is some subject matter expertise required in an arbitration. If the person who's making the decision is going to make a decision based on some contractual clause, some point, so property tax arbitrations, for example, the arbitrator should know something about how properties are valued, right? So that they can give a ruling as to what a property's value should be for tax purposes for a particular year. That makes sense. Yes, so let's talk a bit about how these are used in the real estate space, shall we? Mediation. So if you are involved in residential real estate, use the 1 to 4 family contract, for example, there is a mediation clause in there. Now, when I took my initial pre-licensing courses, there was no mediation clause in the contract, but there was a mediation addendum that you could attach to the contract if the parties agreed to submit disputes to mediation as opposed to suing each other. Now the mediation clause is just built into the contract. It's become more standardized. People are familiar with it. People understand it. It just says you'll submit the dispute to mediation before you sue each other. If you are a realtor and you have a dispute with another realtor, then as part of your realtor membership, you've agreed to not sue each other for certain types of disputes, and instead submit it to dispute resolution, administered through the realtors. So mediation is kind of an initial step in that. I would also say that at least in the world of realtors, a common initial step is essentially a form of early neutral evaluation. The realtors call it their ombuds program. Talk more about that in a future week, I think. But the basic idea is when the realtors get a complaint, and you might ask, what do they get a complaint about? If a realtor member has been accused of certain contractual violations by another realtor, or by a party to a transaction, or a member of the public, or whatever, about violating the code of ethics, that would be the subject of a realtor dispute. If someone's violated the License Act or committed a deceptive trade practice, then that wouldn't go to a realtor board. That would either go to like TREC, for example, as a license holder complaint, or just like a private lawsuit if it was a deceptive trade practice, for example. Now, there are disputes that can bridge multiple forums, right? That, there was a complaint filed with the realtors, also a complaint filed with TREC, and also a lawsuit filed, right? So then you kind of have to figure out what order these should be heard and resolved in. But yes, they're ombuds programs. So if you file a complaint with the realtors, then they will assign that complaint to a volunteer ombudsman. And usually it's members of the professional standards committee who agree to take a shift, essentially like a 2-week period during the year, where they'll get some calls or get some cases assigned as an ombuds. And they'll get some information about the case. And I've done this before. I'll say I get some information about the case. And it tells me who the parties are, what the dispute is. And basically the brief is, see if you can resolve this informally without it going any further. So I will call the complainant, say, hey, what's going on here? And they'll tell me. Then I'll call the party against whom the complaint was made. Let's call them the respondent. And I will ask them what's going on. And also, sometimes that's the first they've learned they've been the subject of a complaint. Some people take that better than others. Sometimes I will call the complainant, and they'll tell me what's going on. And they'll say, I just wanted to get this off my chest. I don't need to take this any further. And sometimes I think what's going on here is bad. Something needs to happen, right? So the idea is this a situation that we can resolve informally, that we can get whatever the dispute is, whatever the problem is, get the parties to hash that out, right? So interesting part of the ombuds program is we don't put anything in writing until we summarize the case and send it back to Texas Realtors. But it's not like we're helping them draft a resolution agreement. We're not sending emails. It's all phone calls. It's very interesting in that perspective. Again, it's supposed to be very informal. Typically, the next step is going to be mediation of some form. Sometimes parties will skip to that, and we'll go into some form of arbitration, which is either a grievance tribunal, a hearing panel, something that might be called formally an arbitration panel. Usually, if it's called an arbitration panel, that has specifically to do with compensation, that the parties are arguing over who that compensation belongs to. So it's a procuring cause dispute. Um, but yeah, then X many people will be appointed to a panel. We will hear the parties present their evidence, and then we will make a decision. And there's also an appeals process to that decision, but generally, um, it has to stay within the realtor ecosystem because the parties involved have agreed to keep it within the realtor ecosystem. But yeah, those are some common scenarios in which ADR methods are uh, deployed in the real estate field. Um, I think what else I've seen as far as these coming up. Um, did I talk about confidentiality? I may not have. This is an important part of any dispute resolution proceeding, is that the impartial third party may not disclose to either party information given in confidence by the other, and shall at all times maintain confidentiality with respect to communications relating to the subject matter of the dispute. Unless the parties agree otherwise, all matters, including the conduct and demeanor of the parties and their counsel during the settlement process, are confidential and may never be disclosed to anyone, including the appointing court. Um, Now, it is important to note that if, in the course of an ADR procedure, any participant, including the neutral, is provided with information that leads them to believe that the child has been, is currently, or may be abused or neglected, they have a legal duty to personally report that abuse within 48 hours to local or state law enforcement agency. So essentially, neutrals are considered mandated reporters if it comes to child or, I believe, elder abuse. But as a teacher, I'm used to that, right? And anyone who's involved who's an attorney would be used to that sort of thing as well. So, but otherwise, very strict confidentiality in ADR. Even the appointing court can't come back and say, okay, but what did they say? And the whole reason it mentioned the, what was it? The conduct and demeanor of the parties. Now, occasionally I will get just a flat question. Did one of the parties not negotiate or participate in good faith? All right. So that's usually important to note because if parties don't participate in good faith, then they could be censured by the court. So a neutral might occasionally be asked that, and that's okay. But otherwise, there'd be no additional questions. How do you know they didn't participate in good faith? What does it mean? What were they like during the hearing, right? That all would not be covered. It's just a simple question. Did they participate in good faith or not? That is something to consider as well. I've talked to some other brokers who've served as mediators for real estate disputes, and sometimes the parties show up and they're ready to get to it. They're like, you know what, this has dragged on long enough. I would love to just get this settled and get it done with, right? And sometimes a party will show up and say, you know what, I'm here because I have to be here, right? Contractually, I have to be here, or the judge said I had to be here. And so I'm going to be here. I'll sit here all day. That's fine with me. But yeah, I'm not going to participate. And that's their, I guess that's their prerogative, right? I mean, if they wanted to put on more of a show, if it was a situation where they could be censured for not participating in good faith, they could put on a show about like, oh, I'm so interested in settling, and then just every time there's discussions or proposals, like, no, this isn't what I wanted. This doesn't go far enough, or they're leaving out some important things. Yeah, but it's in a way it's their dime because typically the two parties each jointly pay the mediator. So if one of the parties wants to put in their money and not avail themselves of the opportunity, they can do that. But what I would say is, and I heard a mediator say this once, and I think it was a really good. I think it was a really good point, and that is a great opening line. Is that every other day in a dispute is about you being right. Right? That's how these disputes get started. Both parties think they're right. Both parties take this to court or complaint or whatever. Disputes start with both parties being right. Every other day of this dispute, from start to finish, is about you being right. Today is different. Today is about you trying to reach an agreement to settle this dispute. And you only have to do that today. But I think that's a real powerful statement. Like, you can have this mindset every other day of your dispute and every other day after if you want to, because I'm sure a lot of people will be replaying it, right? Whether you prevail, and as we saw, even the people that prevail frequently are worse off than before they started. So whether you prevail in this dispute or not, and if you don't, whether you do or not, you're probably going to be replaying this. I think I said that. This dispute every other day after, you can think about how right you were. Isn't that wonderful? Today is the day for you to think about how to settle this. What would a settlement look like? And of course, in the future week, we'll talk a little bit more about this. But in mediations, beforehand, we'll typically assign a little homework. We'll ask the parties to prepare what's called a BATNA and a WATNA. Best alternative to negotiated agreement and worst alternative to negotiated agreement. Once they have done that, they will understand what a good settlement would look like and what a bad settlement looks like. Right? So something we'll talk about in future cases, in future live sessions, rather. Okay, well, I think I've rambled for enough time today to myself. That's fun, though. I will do this again next week as well. My goal is to keep doing these regularly, and in so doing, to help build up additional material to round out some courses, come up with ideas for new courses, not look too silly if my nose is itching on camera. Yeah, just generally delve into some topics. I'm sure I'll say a thing offhand and later think, "Ooh, that'd be a good discussion point for a whole live session." Great, I'll do that in a future week. I'll start making a list. Right? Frankly, I should make a list and put it on the Substack, or make a forum and put it on the Substack, or ask people to reply. What would you like to see as the topic for a future live session? With the caveat that I'm not necessarily here to give real estate advice. I'm here to help people learn about real estate topics. So maybe that's what I should put. Is there a real estate topic you would like to learn more about? How about that? Because of course, when I write courses, they are generally geared towards real estate license holders, right, or real estate professionals. But at the same time, if a really cool idea for a course comes up, and the idea would be it's geared towards the member of the public who is not involved in real estate but would like very much to learn about a certain aspect of it, absolutely, I could create a course based on that. Wouldn't be a CE course; it'd just be like a general, hey, members of the public, learn about this. Yeah, so perhaps I will put that up on the Substack and just get people to comment on it. Isn't that a fun way to drive engagement? Driving engagement. That's what people talk about with any sort of social media or public-facing things. Isn't that fun? All right. Well, I've probably rambled at myself for long enough. I shall end this for today. If you are watching this, well, no one's watching this right now. But if you're watching this later, thanks. I appreciate that. And whether it's the full thing or the clip or just what have you, or maybe you watch the first few minutes and then you skip to the end just to see what was going on. I fear that you have learned nothing worthwhile by doing so, or maybe you think you have. If so, congratulations to you. All right, see you next week.